Hello and welcome to Devil's Advocate and a special interview on the Verma Committee report with the chairman of the committee, former Chief Justice of India, Jagdish Sharan Verma. Chief Justice Verma, in your conclusion you state, the existing laws, if faithfully and efficiently implemented, are sufficient to maintain law and order and to protect the safety and dignity of women and to punish any offenders. And yet, side by side, you've also recommended a whole host of new offences and a whole range of enhanced punishments. Isn't there a contradiction here?
No. Laws need to be updated from time to time.
So this is your recommendations, both in terms of new offences and in terms of enhanced punishment, is updating the law.
Updating the law.
Now, you had some 80,000 recommendations to consider, yet you only gave yourself 1 month to do so. How committed and how confident are you of your recommendations? Or is there room for you to reconsider some of them?
Every one of them was read. There was a dedicated team of youngsters who did it.
So you stand behind all your recommendations?
Yes.
You don't think there's need to reconsider any of them?
Nothing.
Let's then come to some of the recommendations which have met with criticism. To begin with, you've recommended new offences such as stalking, voyeurism, acid attacks, which absolutely no one would disagree with. But you also recommended breach of command responsibility, which makes senior officers in the army or the police forces accountable and responsible for sexual offences committed by their subordinates. People ask, why should a boss be held accountable for offences committed by an adult junior?
Because of the failure of his duty to act when his office demands that. If he has knowledge of it and he does not act, that is facilitating the ultimate act performed by his subordinate.
Now, people in the army point out that commanding officers often have as many as 1,000 or more men under them, spread out over an area of 5 square kilometers. If one of them misbehaves at night or when he's off duty, why should the commanding officer end up serving 7 years in jail, extendable to 10?
It would depend on the facts of each case, and therefore, if the rape occurred or sexual assault occurred in a situation which could have been averted by timely preventive measures taken by the boss, then certainly he has to be liable.
You don't think it's unfair to inflict the offences of a junior onto his boss simply because you believe the boss is responsible for everything the junior does?
Not everything. Only those things which he could have averted if he had discharged his responsibility.
There's an element of subjective interpretation in that phrase, could have averted if he'd exercised his responsibility. Doesn't that lead to unfairness and arbitrariness?
No, that's a question of fact in each case. And that will depend on the facts of the case and the evidence led to prove that he could have acted when he did not.
I'll tell you why people are concerned that there's an element of subjective interpretation which will lead to arbitrariness. People say that this particular recommendation, if accepted by the government, could lead to anti-army groups foisting false charges not just on Jawans but on commanding officers. Your recommendation in their hands becomes a powerful weapon for mischief.
But then that is where the courts will be there to see that false cases don't end up in conviction.
Except for the fact that the false case itself is harassment, officers will be harassed as a way of targeting the army, as a way of carrying out vendetta against authority. And no doubt the court may come down on their side eventually, but what about the harassment before that?
But then that happens in every false case. And can we say that there are no false cases under different laws even now?
So you have no qualms about the fact that this will encourage false cases?
No.
All right, let's come to a second area of concern. Even in cases of gang rapes leading to death or leading to the victim being left in a permanent vegetative state, your committee has been reluctant to recommend the death penalty, which means that in the case of the girl you call Nirbhay, who was gang raped and murdered, under your recommendations, the men responsible would not get the death penalty. Why?
You see, it is this. That was the unanimous opinion of even the women leaders who have been fighting for this cause for decades. And you see, even otherwise, the current trend is against the death penalty.
Gopal Subramaniam, one of your committee members, has gone on record to say that the three of you were inclined to recommend the death penalty but under the influence of women's leaders and women's activist groups, you changed your mind. Is that true?
It's like this. You see, we seriously discussed this issue as very relevant and ultimately came to this conclusion based on, because ultimately, if all the women's group feel that way, who are the biggest stakeholders? And in the current trend of abolition of death penalty for all offences, we did not want to add one more to death penalty.
So your opinion was swayed by two things: the fact that all women's groups that you spoke to were against the death penalty, and secondly, because your own personal attitude to the death penalty is that it ought to be abolished and not implemented.
Actually, swayed may not be the correct way. We took into account all points of view and ultimately came to the conclusion that this appears to be the most acceptable penalty rather than death penalty.
Well, let me question that by putting this to you. Surely Nirbhay's case is the rarest of the rare. In fact, the truth is, nothing of this sort has ever happened in India before. Therefore, clearly it warrants the death penalty. Why shouldn't it get it?
As a matter of fact, I don't want to comment on the particular case which is sub judice. But then in situations like this, forget Nirbhay, any case where a brutal rape ends in death, well, Section 302 is also there.
Which means that, in fact, if judges in the court wish to give the death penalty, they can.
Of course.
Which means that there is room for your recommendation to be overturned or superseded by a judge.
No, not overturned.
Superseded.
That would be for causing death, 302.
Well, you know, this is very interesting. You pointed at something that I was about to bring up myself. Nirbhay, to use the name you use for the gang rape victim, was both gang raped and murdered. Seen as a murder, her case would clearly qualify for the death penalty. Seen as a gang rape, under your recommendations, it wouldn't. Isn't that difference illogical?
No, it's like this. If you treat these two as separate offenses, then only what you are saying. But a same person being gang raped and killed, you see, when both offenses are simultaneously committed, I mean, that difficulty is not there, whether you had provided for death penalty in gang rape or not.
So, gang rape and killed tried under Section 302 can lead to the death penalty.
So there are two offenses, 376 and 302.
But in terms of 376, your recommendation is either 20 years or the natural life. But tried under 302, it could go to death penalty.
In cases where 302 also is attractive.
So this depends upon either the way the police charge the accused or the way the judge reads the charge.
No, it depends on the facts of the case, if there is death.
All right. So there is room for a death penalty depending on the facts of the case. Regardless of your recommendation, it's not ruled out.
So no, there's no question of our recommendation coming in conflict. 302 still provides for death penalty in rarest of rare cases.
Thirdly, sources in the Ministry of Home Affairs are saying that in fact you and your committee have exceeded your brief. They point out, why did Justice Verma and his committee recommend that the assets and liabilities as filed in an affidavit by a candidate at the time of his or her nomination, if they should be verified by the CAG, and if they turn out to be false, that then becomes grounds for disqualifying the person. They say the brief of this committee was to suggest amendments to the rape law, not to go into assets and liabilities and their verification and how that can become grounds for disqualification. They say you clearly breached and exceeded your brief.
I'm glad that the Home Ministry at least has some response to make, even though it is. But this is because of a narrow vision. Everything which ultimately is connected with or related to women's right to equality, because we have treated this issue and considered it on the basis of the constitutional right to equality, and anything which impacts on women's right to equality, which is a constitutional guarantee, we have gone into.
But sir, how do the false assets and liabilities affect a women's right to equality?
I'm coming to that. Ultimately, laws even relating to women are made in the parliament. Now, that is the legislature. Those persons which with such dubious background or antecedents, if they are to make the laws, then certainly I mean, they are not committed to the constitutional values.
I understand what you're saying. The riposte is this, that you so generously, some would say exaggeratedly, interpreted your brief, that you've gone from simply being asked to suggest amendments to the law of rape to suggesting amendments to India's political system.
You see, I personally have always believed, even while in office as a judge, that all human rights issues have to be viewed as expansively as possible, because every aspect of human dignity is a human right. And anything which impacts on the women's rights directly or indirectly must be covered within this.
Except you've touched on areas that are so tenuous in their connection to women's rights. Some would say they're not connected at all, that people believe that is he trying by some backdoor to give himself access to making political pronouncements and suggesting political recommendations to give a higher profile to that report than it otherwise would have.
You see, we are not concerned with the kind of profile which the politicians, local politicians might think. What we comprehended as the legitimate scope of our remit, that's what we have done. And electoral laws are important because they ultimately affect true representation. And unless there is true representation, the constitutional guarantees cannot be fulfilled.
I'll tell you why people say that actually you've exceeded your remit, and people suspect you've done it because you're playing politics in quotations. Because you've also called for a new law, like the one that exists in the UK, establishing the following: criteria for admission into political parties, internal democracy in political parties, a code of conduct for political parties, transparency in how they receive donations, declaration of their expenses. Now people say none of that has anything to do with rape.
No,
but you've used your remit to suggest amendments to the rape law to make actually political pronouncements. You've taken a political stand. Is that justified?
It's fully justified for the reason that the legislature should be comprised of true representatives of the people who alone would be fully committed to the constitutional philosophy. Gender justice suffers because of the inequality which are met to the women, and unless you have people committed to the constitutional philosophy, and to have people committed to none of these things is something which does not impact on
In
that.
a nutshell, you won't solve the problems the country faces, and in particular problems of gender equality and women abuse, if you don't have good, proper, honorable representatives in parliament.
Now it's like this: if you have murderers and rapists deciding what kind of laws should relate to women, well, I mean, it's very obvious. I mean, their interest, they won't do anything against their vested interest.
Let's take a break at that point, Chief Justice Verma. When I come back, I want to ask you a critical question about the nature of support and assistance you got from the government. Or is it true that the Verma committee was virtually forced to fend for itself? That's in a moment's time. See you after the break. Welcome back to Devil's Advocate, and a special interview with the chairman of the Verma Committee, former Chief Justice of India, Jagdish Sharan Verma. Chief Justice Verma, let me begin by asking you, how exactly was your committee set up? Who rang up, who briefed you, who instructed you?
Mr. Chidambaram, who is not the Home Minister, he rang me up on 23rd December afternoon, apparently at the behest of the Prime Minister, and persuaded me to accept chairing this committee.
So the telephone conversation and the instructions came from Mr. Chidambaram, not from Home Minister Shinde?
No, Home Minister Shinde hasn't we haven't talked to each other till today.
At all?
Not at all.
So in other words, the Prime Minister apparently, as you said, instructed Mr. Chidambaram, who I believe rang you from his constituency.
Yes, he was not in Delhi. He said, I'm in my constituency, but then this is what request I have to make.
So the core central figure in setting up the Verma committee was Mr. Chidambaram, not the Home Minister.
Must be the Prime Minister who spoke through Chidambaram.
And just to clarify, you also said you've had no dealings with the Home Minister at all.
Oh, till today we have had no conversation.
None at all.
None.
Let me come to a second issue. How much support and assistance did the Verma committee get from the government? Is it the case that in areas of critical secretarial staff, and more importantly in the whole area of office infrastructure, you actually had to rely on one of your members, Gopal Subramaniam, not the government?
As a matter of fact, the only infrastructure which we took was supply availability of a couple of rooms as needed in the Vigyan Bhavan, and I and Leela Seth being picked up from Noida from our home and brought back.
You said two very important things. The secretarial assistance, the office infrastructure, was in fact provided by Gopal Subramaniam. Entirely by Gopal Subramaniam?
Yes, from his office. And all these youngsters, 15, 20 who were working, all of them from there.
So you functioned...
And we also went and sat there most of the time.
So you functioned almost entirely out of Gopal Subramaniam's office?
His courtesy.
So beyond offering you a couple of rooms in Vigyan Bhavan, none of the staff, none of the infrastructure was available?
There was one deputy secretary, one Mr. Gupta, who of course he was there, but he was there.
But that's all?
He was there to see, I mean, whatever we needed for whenever we were in the rooms.
Now, if I understood your earlier answer correctly, the most substantive assistance from the government was the offer of a car to take you and Justice Leela Seth from your homes in Noida to Gopal Subramaniam's office and back.
Or Vigyan Bhavan.
And that's it? Yeah. The most substantive thing the government did was to give you use of a car.
Now you see, I mean, to pick up from home and drop us back, we didn't want anything more further.
Now, when parties, when institutions were giving you their recommendations, I believe there was a certain amount of confusion, or perhaps a contretemps, when the Congress recommendation arrived on the night of the 5th of January, and it led to Sonia Gandhi personally ringing and apologizing. Tell us, what exactly happened?
Now that it is known, I must speak about it. Past midnight, someone came and to my residence and wanted to hand over personally the whatever suggestions were there, which of course my servant took. But somehow the Congress President, Mrs. Sonia Gandhi, came to know about it, and she was very gracious. She rang me up personally the next day and profusely apologized, to my great embarrassment. I had to tell her, please don't do that.
So she apologized because you were woken up at midnight to be given the Congress recommendations. And she realized that this was an inappropriate thing to do.
Yes.
They could have been given at any other time.
No, and certainly not at my home.
Now, you've also said on record that some organizations sent their recommendations as late as Tuesday evening. Who are these organizations?
Don't ask me for the details, but those who should have been very much involved in the exercise, it came as late as 22nd evening, 5 o'clock or near about that, at Jorbagh in Gopal's office, when we were proofreading the report and finalizing.
You know, you said those who should have been very much involved in the exercise gave their recommendations literally 12 hours before you actually formally handed in your report. In the interest of transparency, who are these people?
I think it's better. They're certainly quite important people, that's all I can say.
Because they're important people, because they're people who claim they made a great contribution when in fact that is not so and it is fraudulent, I think you should reveal their names.
No, I think, well, I better not.
Let me put it like this. Chief Justice Verma, can you deny, and note my words, can you deny that two people whose recommendations reached you at 5 p.m. on Tuesday evening, barely 12 hours before you were going to hand in your report, are firstly the Prime Minister's Special Advisor Sam Patroda, and secondly the Speaker of the Lok Sabha, Meera Kumar? Can you deny that?
I prefer to keep quiet.
So you're not denying it?
As I said, I'm silent.
If I take that as confirmation that I'm correct, what would you say?
I would say nothing. Keep quiet once again.
Justice Verma, this is so important, I'm going to repeat it. You're deliberately not denying it. And when I asked you if I take your refusal to deny it as confirmation that I'm correct, once again you said you're silent.
I'm concentrating on the more important things. And so I think we'll leave it
I
at
think diplomatically, Justice Verma, you've confirmed what I've said. I'll take that as confirmation. The audience, of course, will judge for themselves. Thank you very much for this interview.
that. Thank you.